If you are ever called upon to sign a contract and you notice the terms
in perpetuity throughout the universe,
stop, collaborate,
and listen.
For those of you who don't know me, I am Viva Frei, a Montreal litigator turned YouTuber, accredited mediator, and I do these things called vlogs. VLAWGS, where we analyze and break down something that's going on in the legal world in terms that can be understood by lawyers and non-lawyers alike. For those of you who have been living under a rock, or for those of you who are just not into the esports world, there is currently a legal battle raging between a gamer named Turner Tenney, PKA, professionally known as, thank you very much internet, what's he PKA? TFUE, TFUE, and his current or soon-to-be former, or in fact currently former, Fortnite team known as FaZe Clan. The nature of the dispute in a nutshell is that TFUE does this thing called esports gaming, and he's on a team with FaZe Clan and 3 other members, and they play Fortnite, and apparently it's like a multi-billion-dollar industry overall esports, and Fortnite is apparently a massive game that people play competitively. I know, I'm getting old. Oh, what's that, doggy? You want to show your face? One. Oh, yeah, there you are. Oh gosh, no. Hey, stop. Do you have anything you want to say to the world? I thought so. So Turner Tenney, TFUE, plays Fortnite in a team with this FaZe Clan team. And he entered into a contract with FaZe Clan which governed their business relationship as relates to esports Fortnite gaming. Okay, get down. Oh! And drama recently broke out because TFUE filed a lawsuit against FaZe Clan in which he alleged material breaches of the contract, that the contract between him and FaZe Clan was illegal, that it violated California law, and I did a video breaking down that lawsuit, so you can go check that out. I'll post a link right here. And since having done that video, apparently the actual contract between TFUE and FaZe Clan was leaked. Now, being a lawyer and being a cynic and being a cynical lawyer, Dude, come on, we're making a video here. I'm a little skeptical that this contract is either authentic or the actual contract. So I'm a little skeptical that this may or may not be the actual contract between TFUE and FaZe Clan, because the contract that I'm looking at that has theblast.com watermarked all over the place provides that the governing law and jurisdiction is that of New York. Whereas the lawsuit between TFUE and FaZe Clan was filed in California, Los Angeles. Now, I did notice that there are allegations in the lawsuit between TFUE and FaZe Clan explaining why the District of Los Angeles in California was the proper jurisdiction to hear the dispute, but it certainly did not make any reference to a governing law or jurisdiction clause in the contract. Regardless, we're going to break down this contract clause by clause, or relevant clause by relevant clause, because whether or not it is the current or existing or binding contract between TFUE and FaZe Clan, it can teach us what we should be looking for in contracts, or at the very least where flags should be going off and where you should be saying, yes, I may need to get the advice of a professional. And in order to cover my tushy, let me just open up these standard parentheses. I am a Quebec lawyer. I am not certified to practice in the United States, nor am I certified to practice in the other provinces in Canada or elsewhere. Nothing in this video constitutes legal advice. If you need legal advice, consult an attorney in your proper jurisdiction who is competent in the domain that you need legal advice in. This is for entertainment and educational purposes only. The things that I'm talking about are really 30,000-foot overviews. Let's read this contract, shall we? The Gamer Agreement. This Gamer Agreement, dated as of April 27th, 2018, is entered into by and between the company as defined below and Gamer as defined below. For the purposes of this agreement, each company and Gamer may be individually referred to as a party. This agreement shall be subject to the terms and conditions attached hereto as Exhibit A, which are hereby incorporated by reference herein as the TNC. Capitalized terms, blah, blah, blah. Okay, who cares? Company, FaZe Clan, Gamer, TFUE, Game, Fortnite. So one thing that is really cool about all of this is that this is like an entirely new domain, and I'm not old, but I'm not young, and I'm sort of in between the ages of young and old, where I can remember what it was like to be young, but I can foresee what it's like to be old. But when I see a legal contract between parties governing their relationship as relates to playing Fortnite, I start to feel like I'm maybe playing more of the back nine of the golf course than the front nine. Let's keep going. Company's competitive online esport video gaming team for the game, which, as the effective date, consists of 4 gamers: Turner Tenney, Tang Tan Fan, Dennis Leopold, and Brendan Martin O'Brien. Notwithstanding the foregoing or any term contained herein, company, in its sole discretion, may increase or decrease the number of gamers on the team from time to time. Alright, so reading this provision, any of the members of the team have to be aware of the fact that the team can be made bigger or the team can be made smaller. If the team is made smaller, that presumably means that the company, capital C defined term, cuts one or more of the players from the team. First provision provision of interest. Term right of first refusal. Now, the concept of a term is pretty self-explanatory. It refers to the duration of the contract. Typically, contracts have an initial term, and they will have renewal of terms, provided that none of the parties are in material breach of the contract, unless earlier terminated by the parties pursuant to the terms of the T&C attached hereto and incorporated by reference herein. The initial term of this agreement shall be 6 months from the effective date. At the end of the term, and notwithstanding anything to the contrary set forth in this agreement shall be automatically extended for an additional 36 months, provided the following conditions have been met. And then it basically goes on just to set out that if the parties have not breached their respective obligations under the agreement, that the contract will be automatically renewed for an additional 36 months or 3 years. Although it is interesting to see what the respective obligations are that this renewal is conditional upon, so let's just do it quickly. The gamer receives their monthly fee. The gamer has appeared in one company-created content published once per month on either company's YouTube or Twitter platform. FaZe Clan member has appeared in gamer-created content published on one of gamer's personal social media platforms. Company has supplied gamer with gaming setup, including commercially standard quality gaming headsets, monitors, computer equipment, and upon gamer and company's mutual agreement, a gaming chair to be used for the purposes of this agreement. But can your chair do this? I'm not gonna fall over and kill myself for a vlog here. Let's just keep going. Company has provided gamer with FaZe Clan player kit and FaZe Clan merchandise. And this is where it gets interesting and relates to a concept that a lot of people might not be all that familiar with, the right of first refusal. Now, in layperson's terms, we know what the right of first refusal is. It means that a designated person has the right, before anyone else, to do something. To buy a house, to buy a car. There are consequences to right of first refusals, which we'll talk about in a second, but let's just see what we're talking about right now. At the end of the extended term, gamer and company shall enter into a 30-day negotiation period regarding the renewal terms for this agreement. Provided, however, if an agreement is not reached during the negotiation period, gamers shall be entitled to seek an offer from third-party organizations during the 30-day period following the negotiation period. Now, there is a risk that when you talk about sequential periods, you get sort of confused as to when one starts, when one ends, and how things sort of follow chronologically. But what this is basically saying is that at the end of the agreement, the parties have 30 days to enter into a new agreement and negotiate the terms of that. And after that, if they can't negotiate a mutually acceptable agreement, there's an additional 30 days wherein, if TFUE gets an offer from another Fortnite team, FaZe Clan would have the right of first refusal to match the terms of that offer from a third party, such that TFUE would have to enter into a contract with FaZe Clan under the same terms and conditions as the offer received from that other third party Fortnite team. So very important to understand what that means in the context of this agreement. It means that after the 36-month term of the agreement, the parties have the obligation within a period of 30 days to try to negotiate the terms of a new agreement. But if the parties don't successfully negotiate the terms of the renewal of this agreement in that 30-day period, TFUE is not off the hook just yet. If, following the failed 30-day period to negotiate the terms of a new agreement, TFUE receives an offer from another Fortnite team to play with them, FaZe Clan still can bind TFUE to play with them by matching the offer of that third-party gaming Fortnite team. And it's only in the event that FaZe Clan elects not to make a matching offer of that third-party offer from another Fortnite team that TFUE is officially off the hook, free to play with that team. This agreement is terminated, no more agreement, period. Interesting. And then we get into the gamer services, which are basically the obligations of the gamer under the terms of the agreement. Obviously, he has to play games with the company. He has certain publicity obligations, which seem to amount to no more than 3 days per month for a total of 24 hours in any month. The gamer, TFUE, has to represent the company's sponsors, represent the company in social media, participate in the team's training sessions, participate in all LAN tournaments, major tournaments, league matches, etc., etc. In any agreement, both parties to the agreement are going to have rights and obligations. So right now we are setting out the gamer's obligations under the terms of this gaming agreement, and we are going to get into the company or FaZe Clan's obligations under the agreement under the section of compensation as full and complete consideration for the services to be provided and all rights granted by gamer hereunder, and provided gamer is not in breach or default of the terms of this agreement, including without limitation the T&C is attached hereto and incorporated by reference herein. Companies shall pay the gamer the following compensation: $2,000 a month, the monthly fee. There is a very interesting caveat in this that we have to pay attention to. Now let's read it. Notwithstanding the foregoing, such compensation shall be subjected to a review at the end of each 6-month period of the term. As a result of such reviews, gamers' compensation may, at company's sole discretion, increase by up to 25% or decrease by up to 25%. Now, in law, there are these terms that we call purely discretionary terms. In French, it's called des conditions purement potestatives, meaning that it is solely up to the discretion of one of the contracting parties, and these are not always recognized as lawfully binding, because there is no objective, measurable way in which these rights are to be exercised if they are just purely discretionary of one of the parties. How do they feel that day? TFUE, I think I'm gonna lower your compensation by 25%. So this clause is very interesting in terms of the exposure that it creates. At the end of a 6-month period, the company can elect to increase the monthly compensation by 25%, but they can also, at their sole discretion, without any justification, for no reason whatsoever, decide to lower it by 25%, without consequence and without rights or recourse by TFUE as drafted under this agreement. That would be a problem for me as TFUE's attorney. Now it's starting to rain a little bit much. We're gonna go inside and finish this up there. All right, one last thing on these purely discretionary clauses before we move on. You can have purely discretionary clauses where a party gets to terminate a contract because it wants to. But typically there are going to be penalty clauses or notice clauses or compensation clauses that will follow from the discretionary exercising of a right to terminate. But the arbitrary and purely discretional right to lower someone's remuneration just because without any objective criteria or unit of measurement in order to know how a party is going to exercise that right becomes more problematic. Now, you can terminate a contract because you want to, because people cannot be bound in contract together. You can get out of the agreement at your sole discretion, but you might have to pay some money in order to do so. But I believe that there could be enforcement issues with this type of clause that basically says, I'll pay you less if I so choose. All income generated by gamer from cash prizes won in any tournaments and or matches shall be split after any payments to the team coach.
There's a Fortnite team coach?
What? This is madness! Where were we? As follows, 80% to the gamer, 20% to the company. Now there are always going to be revenue splits under these types of contracts, under video licensing agreements, under MCNs. There are always going to be revenue splitting provisions as relates to the income generated either individually or collectively as an enterprise. So the only real business question is going to be whether or not the split is commensurate with market value, commensurate with the industry standard, fair, reasonable, or just better for one party than for the other. And it varies by industry, and I have no idea about what the industry standard is for Fortnite or esports gaming. But the splits are going to be negotiated between the parties, and there may or may not be room for negotiation depending on the respective powers of each of the parties. Brand deals featuring the gamer that exist on gamer or company's content creation platforms, e.g. Twitch, YouTube, or social media sites, if the deal is brought to company by gamer, 50-50. Now that may seem unfair because why should the company get 50% of a brand deal that the gamer brings? The justification would be that the reason some brands approach the gamer is in particular because of his association with the company in the first place. TFUE as an individual might not attract the same brand deals that TFUE as part of the FaZe clan team might generate. Brands might only approach TFUE because of his association with FaZe Clan. Therefore, there is some value being brought by FaZe Clan's association with TFUE that would justify a percentage of the revenue. Whether or not it's 50-50, 60-40, 70-30, whatever, that's for the negotiations between the parties, but that is the justification for the split to begin with. Team merchandise and apparel featuring gamer or gamer's likeness. Unrelated to FaZe Clan's merchandise and apparel manufactured by or in conjunction or in consultation with company, after deduction of all costs in connection with such merchandise and apparel, 20% to the gamer and 80% to the company. And this is the one in particular that got a lot of bad press in people's reactions to the TFUE's FaZe Clan dispute. And not only does it seem excessive on its face that only 20% would go to the gamer for his likeness and 80% to the company, it's also after deducting all costs in connection with that merchandise or apparel. And here the lawyer flag goes off, what are included in costs? If the company provides consulting for the manufacture or design of the merchandise or apparel, are they entitled to get paid for that? And does that go to the company before they even have the 80-20 split in favor of the company? There could be nothing left to split after the costs are deducted. This is why I go on the roof. Okay, let's go to payment terms now. This payment term is very interesting. All prizes and other income generated in connection with this agreement shall be payable to and collected by a company, and company shall account and pay gamer his or her share of such income on a monthly basis within 30 days after the end of each month. Gamer acknowledges and agrees that company shall have the right to include a direction of payment clause in all contracts entered into by gamer, directing all income to be paid directly to the company. In the event that any person or entity pays any income directly to the gamer, gamer agrees that he or she shall promptly transfer all such income to the company for collecting and accounting. All right, so you see what's going on here. This is also a very dangerous clause because it basically provides that any and all income either goes to the company directly, or if it happens to go to the gamer has to remit it to the company so the company can do its own accounting, deduct whatever is owing to it under this agreement, and then remit the balance to the gamer at the end of the month. A direction of payment is basically the recipient indicating to the payer not to pay the recipient, but rather to pay a third party. And it's something that I talked about in the analysis with MatPat and Defy Media and all MCNs who basically get the payments directly for and on behalf of their client and then deduct whatever is owing to them to remit the balance to their clients. The risks are that if a company goes bankrupt while it is holding monies that it owes to somebody else. If the company goes bankrupt, those monies don't go to the person to whom they are owed. They form part of the assets of the estate, and they are prorated among all creditors to the company. The other thing to note is that the direction of payment we also discussed in the Michael Avenatti indictment, where the client he was representing, named Victim 1, but whom we all know to be Stormy Daniels, was to receive payments from a publisher for a book that she was about to write, and Michael Avenatti asked the agent to remit the fees to his account in trust, and the agent said, no, we can't do that in the absence of a direction of payment from your client. And apparently, according to Michael Avenatti's indictment, instead of getting a direction of payment from his client, Victim 1, he actually forged, falsified, or fabricated a direction of payment, received the monies for and on behalf of his client, and then never remitted them to his client. Whatever. Side note, I'll link that video right here. Most of the new faces around here have probably already seen it, but if you haven't, go check it out. It's a good one. The relationship of parties provision is very interesting. In my original video breaking down the TFUE lawsuit, I said it wasn't clear what type of contract this was. Was it an employment contract, an agency agreement, a licensing agreement? In the relationship of parties, the parties are attempting to define contractually what their relationship is. And although this can be done, it does occasionally cause problems, and we're going to get into it right
Now the kid is screaming.
It does occasionally cause problems, and we're going to get into that right now, but let's just read the provision. Each party is an independent contractor and is solely responsible for all of its own employees, subcontractors, labor costs, and, except as otherwise provided herein, expenses, including without limitation, timely payment of all income taxes, payroll taxes, and related withholdings arising in connection therewith. Now again, speaking to the only jurisdiction that I know and in which I have practiced, providing in a contract that someone is not an employee from the taxing authorities is not necessarily going to be accepted by the taxing authorities. There is a point after which, for governmental authorities, an independent contractor actually in law becomes an employee to the company. And typically those considerations include things like oversight. Does the company exercise total oversight over the contractor? If yes, they can be deemed to be an employee. Does the bulk of the independent contractor's remuneration come from one entity? If TFUE's only income comes through FaZe Clan, then the parties can provide that he is an independent contractor, but in law he might in fact be an employee. The agreement can provide that TFUE is a subcontractor, but under California law, FaZe Clan might actually be an agent. I don't know. But these are considerations. It's not because the parties define themselves one way in the contract that in law they will be recognized as such. And miscellaneous. This agreement shall be governed and construed in accordance with the laws of the state of New York. The parties submit exclusively to the state or federal courts located in New York, New York. This is why I'm suspicious that this is not actually the contract between TFUE and FaZe Clan, or it's not the contract that's currently in force, because they filed a lawsuit in Los Angeles, so unless the parties consented to the jurisdiction of the courts of Los Angeles, contractually they have submitted to the courts of New York and the governing law of New York. Regardless, we'll see where this goes. That might be what we call in Quebec law a preliminary exception. That might be what defendants are going to raise to say that this lawsuit that TFUE filed in California should actually be moved to the courts of New York and be governed by New York law. We'll see. Okay, whatever. What else do we have in here? Okay, I don't think we have anything more important in miscellaneous. Let's just keep going. And then we get into the terms and conditions, Exhibit A, an annex to the agreement itself. And the devil is in the details. These terms and conditions are important to say the least. Gamers shall render all services in a first-class professional manner and shall be subject to the instructions and direction of company and its designated representatives. And this goes back to what I said earlier about specifying that the gamer TFUE is a subcontractor and not an employee. This is starting to sound a lot like an employee's obligations towards the employer and the employer's authority over the employee. Typically, subcontractors are independent and can do what they want the way they want to do it. They are not subject to the absolute oversight of the other party, because then they could be deemed to become an employee. We have a lot of noise and the kid doesn't want to wear a jacket. Section F, gamers shall comply with company's traveling routines, reporting requirements, and safety policies as instructed by company from time to time. And H is very important. Gamer will not accept any money, services, or other valuable consideration other than the compensation payable by company hereunder. It sounds like the gamer is under the absolute direction and control of the company, because he is. That's why this contract is excessively onerous for the gamer TFUE for the benefit of the company. I'm not saying that in a judgmental way. It's just a very one-sided contract. The flip side to that argument is that although this might be very beneficial to the company, it offers opportunities to TFUE that he might have otherwise never had access to, but for entering into this agreement with the company. Regardless, these are business decisions, business considerations. The most important thing is only to have read the contract, understood the contract, and know what you are signing off on. And then you get into Section 3, fines for failure to provide services. And you can take the time to read the provision, but not only is the gamer susceptible of penalties in the event that he breaches his obligations under this agreement, he's subject to a $125 25% penalty in the event that he does not meet up at a LAN tournament or breaches his confidentiality obligations under the agreement. That is to say that the penalty is actually more than his compensation under the agreement. And the intellectual property provisions of this agreement are perhaps the most important to fully appreciate. Gamer services hereunder shall be performed on a work-made-for-hire basis, and as such, all right, title, and interest in and to all results and proceeds from the services, including but not limited to all work product, deliverables, and content, and all intellectual property rights therein and related thereto, shall be owned exclusively by company in perpetuity throughout the universe, and in all media now known or hereafter devised.
That is how someone gets owned.
It basically means that TFUE has no rights to any intellectual property he produces while under this agreement. And again, this is where we are skirting the line between independent contractor and employee. Employees, when they are rendering services for their employer, do not own the intellectual property in the work produced in the context of their employment. Quite logically, because they are being paid to produce that for their employer, it would make no sense for them to own the intellectual property rights to the product of their work for their employer. That said, independent contractors can surrender the intellectual property rights of the work they produce, and typically they're going to do it for some sort of valid and commensurate compensation. But all that to say is that under this Section 4 intellectual property, Gamer is abandoning any and all rights to all intellectual property in perpetuity throughout the universe. And the parties have to appreciate the legal implications that may follow as a result of the relationship they are creating between each other. It's very nice for the company to provide in the agreement that they own any and all intellectual property, that they can tell the gamer what to do when and where, that the gamer has to render all services in accordance with the company's demands and wishes. But they might actually be creating a legal relationship whereby the gamer is not an independent contractor, but in fact an employee with employee rights. And then we have Section 4C, gamer name and likeness, whereby the gamer, TFUE, is basically giving the company the rights to his name, image, and likeness. It's not rocket science, it's just that people don't typically understand the scope and implications of what they are signing off on until there's a problem. Until one of them wants out of the contract, but whoa, they can't use their likeness, name, or image on their own for a certain period of time because they have given that exclusivity to their contracting party, as is the case in this agreement, and we'll get into it. Section 5, exclusivity and matching right. Throughout the term, unless gamer has obtained the company's prior written consent, gamer shall not provide services or otherwise work for or be employed by a gaming company or other gaming brands or any companies that already have an agreement with company. Appear in, sponsor or be sponsored by, or otherwise promote or endorse directly or indirectly any brands, products, or services other than the brands, products, and services approved in writing by company. Promote, sponsor, endorse using gamer's name and likeness or otherwise, or render services for or on behalf of any companies with products or services competitive with a product or service of company or a sponsor or advertiser of company. And we saw how this played out in the actual lawsuit, where TFUE said that the company denied a sponsorship because they thought it competed with one of their existing sponsors. The result being that they deprived TFUE of revenue that he could have otherwise brought in either for the company or for himself personally, because the company owns his name and likeness during the term of the agreement and could in fact prevent him from entering into that contract with a third party as per these terms. If at any time prior to the end of the exclusivity period or within 3 months thereafter, gamer receives an offer from another Fortnite team to join such team upon lawful termination of the agreement by gamer, gamer shall be obligated to provide the offer to company and the identity of the party providing the offer, and company shall have the right to match such offer during a period of 15 business days following company's actual receipt of the offer. Now, one has to appreciate what this means and what the actual business implications are of a right of first refusal, a matching right. If TFUE gets an offer from another Fortnite team, he has to first give the matching right to FaZe Clan, meaning that FaZe Clan can come in and say, okay, we are matching the terms of that contract and we are buying back TFUE, or we are contracting back with TFUE. But normally TFUE is going to have to disclose that fact to any party making an offer to him. Because if another Fortnite team makes an offer to TFUE not knowing that FaZe Clan has the right to match that offer, they are going to be peeved, to say the least. Knowing that their offer is going to be disclosed to FaZe Clan and that FaZe Clan has the rights to match that offer and take back TFUE from the grips of that other Fortnite team. And it will have business implications for TFUE because any party that he's going to negotiate with, knowing that FaZe Clan has a right of first refusal to match any offer that they make, it's going to impact the amount of the offer they're going to make. It might be a deterrent for that other party to make an offer. In theory, I guess it could be a negotiating tool for TFUE to say to the other party, look, make me a really good offer so that FaZe Clan can't match it. But practically speaking, I think it would be more of an impediment than a benefit to TFUE, because any party is not really going to want to make offers knowing that FaZe Clan will have the right to match that offer. They might not even want FaZe Clan to know that they're bidding on TFUE. But it's in this contract, which is grossly lopsided in favor of the company, notwithstanding the argument that by having entered into it, TFUE might have gotten business opportunities that he would have never otherwise gotten. and exposure that he might not have ever otherwise gotten. But those are the business considerations when negotiating this. On its face, this is extremely favorable to the company and extremely onerous to TFUE. Section 6B, termination. Termination for convenience. Company may terminate the agreement at any time upon 30 days prior written notice to gamer in the event that company wishes, in its sole discretion, to replace gamer with a new person on the team, provided that gamer shall be paid for all services satisfactorily completed prior to the effective date of such termination. That's it. Company can terminate on 30 days notice. Period. Does TFUE have the same right?
I suspect not.
Termination for morals breach. In the event that gamer takes any action that constitutes an offense involving moral turpitude under federal statute or local laws. Alright, whatever. Morality clause. If the gamer behaves badly, company can terminate. I suspect a morality clause was what ABC invoked in order to terminate Roseanne's contract after her now infamous tweet. I suspect it's what Disney invoked in order to cancel PewDiePie's contract. Typically, these types of contracts are all going to include a morality clause because nobody wants to be contractually bound to someone who behaves publicly in a manner that tarnishes the image of the other party. And then you have termination for material breach, which is a mutual right by both parties. If either party does not respect its obligations under the contract, the other party can terminate. And then we have obligations on termination, and this one is a doozy as well. Obligations upon termination. Upon termination of the agreement for any reason, gamer shall promptly provide company all results and proceeds in any stage of completion through the date of termination, all documents or other media containing confidential information, and all equipment gamer has received from company during the term. Unless termination is pursuant to a gamer material breach, company shall pay gamer applicable compensation for services rendered through the effective date of termination. This would seem to imply that if the termination was for gamer breach, that the company would not pay what it otherwise owes to the gamer. Interesting, but just something to note. Additionally, notwithstanding anything to the contrary contained in the agreement, in the event of termination for a gamer material breach, gamer shall be prohibited from playing video games publicly, online, or in live tournaments, or professionally for a period of 6 months from the effective date of such termination. So in the event of termination for gamer material breach, apparently the company not only doesn't have to pay what it would otherwise owe to the gamer, but the gamer is precluded from competing publicly for 6 months after the termination. You can now easily understand why TFUE filed a lawsuit for declaratory relief to declare that the contract has been terminated. Specifically so that TFUE can go on and earn a livelihood without being bound by these provisions. And it's a strategic decision that the lawyers made. Other lawyers might have said, no, just terminate the contract for material breach, and if the company thinks that it has certain rights and obligations, let the company sue TFUE, enjoining TFUE not to compete publicly in gaming competitions for 6 months. As far as I'm concerned, the optics of that would be even worse. Here you have a poor individual gamer who's been exploited by a one-sided contract. The company defaulted under its obligations under the agreement. The gamer terminates the contract, and then the company takes a lawsuit prohibiting the gamer from earning a livelihood. I think the optics of that would have been much worse. Regardless, hindsight is 20/20, and everyone lives with the strategic consequences of their own decisions. All right, the rest is some standard legalese that we don't really need to get into right now. And then we get to Schedule 1, social media policy. We don't need to go through this one by one, but it's important to know what one is contracting into, because a violation of any of these 10 obligations under the social media policy could be deemed to be a material breach of the agreement, thus resulting in termination for gamer material breach with all of the consequences that we just discussed. All that to say, just important to read through this. You will not bring company or any of its employees, blah, 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 into public disrepute, contempt, scandal, or ridicule. On the internet, good luck with that. There's no coffee left in here. You will not violate any applicable local, state, national, or international law, including but not limited to any rule, regulation, decree, or ordinance. Well, that's very interesting given the fact that TFUE himself, in his lawsuit, admitted to underage drinking and illegal gambling. Although he tried to blame it on the company, he might have made a judicial admission to the effect that he violated Item 2 of the social media policy, which might explain why he subsequently made that video saying that he wanted to remove those allegations from the lawsuit, which goes back to what I said in my previous video that the defendants might object to removing those allegations, which might constitute judicial admissions that the gamer, TFUE, violated the social media policy. Those are the nuances, and that is the nature of the litigation fight. It's dirty, it's vicious, which is why it's not necessarily a lifestyle for everybody. Okay, well that's it. We're done. We're done. If you like this content, please like, share, subscribe, hit the notification bell, drop a thumbs up, leave a comment. You know what to do, and now you know your vlog. Peace out. Boom!